Good morning, everybody. Chapter 2 of the Realtors course, Reps course. Topics, 9 topics. 3 types of licenses, 5 levels of licenses, some parts of the sales process, real estate team requirements, unlicensed assistance duties, acts created by the provincial government, the RESA and the REDMA, the organizations created by RESA, voluntary organizations within the real estate organization, and last is REDMA, the purpose and disclosure requirements. Okay, first topic, 3 types of licenses. Trading services, 3 types of services. Trading services, that's the license that you're going for now. As a realtor, it's called trading services, meaning buying, selling, leasing for your client and perhaps even for yourself. The other 2 types of services are called management services, management of rental property, management of strata property. With your license, which you're getting now with trading services, you are not allowed to do management of rentals and management of strata. You would have to get the other 2 licenses in order for you to do the management. Okay, in trading services, you have what you're going to do is get a realtor's license, which allows a person to do all of these activities. And basically, trading services means you're selling and buying, representing sellers and buyers. Okay, you're finding parties for the real estate, you're showing the real estate, you're negotiating the prices. All these are the activities that you will be doing as a realtor, as a rep. Okay, if you get a property management license, then you'll be doing these. If you get a strata property manager license, then you'll be doing these. Okay, so these are managing licenses. This is the license for selling and buying for your clients and for yourself. All 3 services need separate licenses. You may have more than 1 license. Okay, so the 3 types of licenses, 3 types of services, not 3 types of licenses, 3 types of services that are offered under the Real Estate Services Act are trading services, management of strata, and management of rental. You, when you get your realtor's license, are not allowed to do these 2. Okay, all 3 services need separate licenses. A person can get more than 1 license. Okay, very important for your exam, constructing is not a service under the Real Estate Services Act. Constructing is a license to construct is a separate license. It's not a service under the Real Estate Services Act. So for your exam, be careful with the word construction. Okay. With the realtor's license, you will be able to buy, sell, or lease all types of residential properties, meaning homes, rental properties, strata properties, apartments, townhouses, duplexes, and all types of commercial, industrial properties also, warehouses, and you will also be allowed to sell and buy businesses for your clients or for yourself. Okay, when you're going to get a license, you will have to go get a police record check and supply that to the council. And you will have to make sure you have what's called good reputation, meaning you have not have any frauds or offenses against you. You have not been denied any other licenses, okay? And also you will have to write the exam and pass this exam. And after you pass this exam, then you will also do what's called the post-licensing course. After you've done both of them, you will be able to start working with a brokerage. You never are allowed to work as an independent without a brokerage. When you're working with the brokerage, you are working under the brokerage, but you are still under all the rules of the brokerage. Okay, who needs a license to sell real estate? Anyone who's going to charge any money or give any advice on real estate will need a realtor's license. Who does not need a license? If they want to sell real estate, they will need license. But who does not need a license if they're doing any dealings or any paperwork for real estate, especially if you're just going to sell your own home for sale by owner, you do not need a license. A friend can help another person sell their home, they do not need a license as long as they don't charge any fee or money. Okay, developers employees, when you see people in the pre-sale offices, they can assist buyers. They do not need a license as long as they do not do other assistance of those buyers. Okay, employees of lawyers, notaries, they do not need license, and there's a list of other agencies that do not need licenses. Office staff, okay? If secretaries, conveyancers, or owners of brokerage, if they're not going to do sale or buy of properties for other people, they do not need to be licensed. Okay, 4 levels of licenses, okay? You're going for the lowest level, which is called the rep or the realtor, but there are 3 other levels of licenses. The highest level is the brokerage, and the managing broker is a person who looks after the brokerage, and the managing broker also looks after the rep, and maybe even the associate broker. Associate broker is just a person who has the same license as a managing broker, but is an assistant and is not liable for the reps or the brokerage. The brokerage must be a partnership or a corporation. Okay, all other licenses can be a person. A person can have as all possible combinations of licenses also. So let's do the first one, levels of licenses. There's 4: brokerage, managing broker, associate broker, which is an assistant, and you as a rep, realtor, whatever you want, or a licensee, called also a licensee. 3 different names for the realtor: rep, realtor, and licensee. It's the lowest license, but the highest license is the brokerage. Brokerage is which the Century 21s, Remax, the ones that you work for. You work for a brokerage. As a rep, you will be representing a brokerage, okay? And the brokerage must be a partnership or a corporation. The brokerage, in order to get their license, must file financial statements of corporation with the council to get their license. And they must file all records with the real estate council. The brokerage is the organization that pays the reps. All the money for your commission comes into the brokerage, and the brokerage writes you a check, okay? And the brokerage appoints a managing broker to represent the brokerage. Every brokerage must have a managing broker. If the managing broker loses their license, the brokerage cannot operate. And if the managing broker loses his license, the reps cannot operate either. A brokerage may not promise to offer its services unless full disclosure is made about all the facts to the buyers and the sellers. Okay? All agreements, unless all agreements are signed, that's when the brokerage can start offering any services. Okay, managing broker. Managing broker is a person appointed by the brokerage, hired by the brokerage to represent the brokerage for all the brokerage purposes. He must be 19 years old. He must have 2 years of experience as a rep in the past 5 years. So memorize these 2 numbers. 2 years of experience in the past 5 years. For the exam, they'll switch these numbers around. Sometimes they'll say 3 years, or they'll say in the past 10 years. You have to know this number, okay? They have to, just like you, they have to pass managing brokers exam that's given by the Sauder School of Business. They do not have to be Canadian citizen. They are totally responsible for the brokerage, and they're totally responsible for the supervision of the realtors and the associate broker. If they lose their license, if they do not do a good job of supervision, they may lose their license. The broker may lose their license, managing broker. Okay, managing broker is what's called vicariously responsible, liable for the reps. That means whatever the reps do, the manager is also responsible. Okay, manager could also be disciplined or investigated by the council without any approvals of any courts or at any time they can do investigation. Okay, an associate broker, we're at number 3 now. Associate broker has the same license as a managing broker, but he's an assistant and he is not responsible in any way for the brokerage or for the reps. Last one is you are applying or you are trying to get what's called a realtor's license. Another name for it is a representative. You are a representative of the brokerage. Okay, very important for you to understand that you represent the brokerage. That means everything is owned by the brokerage. Your contracts that you write are owned by the brokerage. Your clients that you have are also belong to the brokerage. Okay, so you is the person getting the license is going to get what's called the lowest entry-level license. You must be 19 years old, and in this one, very important, it's not 2 years of experience. It's renewal of your license happens every 2 years. Mortgage managing brokers licenses also get renewed, but you're not applying for the managing broker's license now. You're applying to get representative license. That's why you need to know that the renewal happens every 2 years. For the managing broker, what you need to know for your exam is they need 2 years of experience in the last 5 years. Very important that you can only work, first of all, you must work for a brokerage. You cannot work independently, and you must work only for one brokerage. Okay. Another important part is whichever service, remember there are 3 services, trading services, and the other 2 are managed strata and managed rental property. If you want to offer all 3 of them or 2 of them, your license, yes, you're allowed to get the licenses, but you can only work under a brokerage that has the same licenses. If the managing broker and the brokerage only have one license, which maybe is a trading services, and you have more than one license, then you're only going to be able to do one service. You can do as many services as you like, but your managing broker and your brokerage must have the same licenses licensed services in order for you to offer the same services. Okay, in terms of advertising, very, very strict rules. We'll talk about rules for advertising when you start listing and then afterwards advertise a listing. Very strict rules for that. Okay, you have to pass this exam, and then you have post licensing course. Once you finish both of these things, then you're allowed to work. You're not allowed to work immediately after passing the licensing exam, which is going to be the 100 multiple choice exam questions offered by Sauder School of Business. Okay, must be employed by a real estate brokerage. We already talked about that. Okay, so cannot sell houses right away after you're done with your licensing exam. That's again on your exam. There's questions which say, can you start immediately after passing this exam? No, you also have to do post-licensing course. Okay, cannot be registered independently, meaning you cannot work without a brokerage. You have to work under a brokerage. Okay, cannot work if the managing broker or the brokerage loses their license, then you will be inoperative. You will not lose your license because the managing broker and the brokerage lost their license, but you may be able to go to a different brokerage and start working. Okay, if you're buying or selling for yourself, you're allowed to, but there are going to be a lot of problems or difficulties with your insurances and errors and omissions, but you are allowed to buy for yourself or sell your own property or for a company that you're associated with. But you must disclose in writing and, very important, before, which means prior to making any contracts with the sellers or buyers, that you are a realtor, that you are, and the purpose of buying or selling. If you're buying, let's say, property, and you have to disclose the reason and what you'll be doing with the property. Maybe you're going to sell it afterwards. As long as you disclose, it's fine. Maybe you're going to renovate and sell. Maybe you're going to renovate and keep. Maybe you're going to keep it as a rental property. Whatever the purpose is, must be disclosed to the seller if you are buying for yourself. And you will be required to tell how much commission you'll be making, and obviously the names of the buyers and the sellers must be disclosed. Rules regarding advertising. When you get a listing or anything else about yourself that you want to, your properties that you want to advertise, very important that the brokerage's name must be displayed in a readable, easily readable. Your name must be there. You must not make any false statements in the advertising. Okay, quickly, must be employed by a brokerage, at least, or only one brokerage. You can only work for one brokerage, and you must work for a brokerage. All the contracts are the ownership of the brokerage that you work for. And you can only offer the service. Remember, there are 3 types of services, and most of you are just going for the trading services. So that means you have to work for a brokerage that has a license to do trading services, and a managing broker that has a license to as a trading services. Okay, you cannot work independently, and you will not be able to work if your managing broker loses their license. You will not lose your license, but you're not allowed to work. Commission, any amount, any percentage, any amounts you can charge. A brokerage will not tell you how much you can charge. Sellers, your clients will not tell you how much. It's up to you as to how much you want to charge. Okay, but all your commissions come through the brokerage. Any bonus or any gift that a client wants to give you must be given to you through the brokerage. There are no secrets or bonuses. You're allowed bonuses, but they must come through the brokerage. Okay, now, for your exam, a different type of commission that you're not allowed, and that is called net. Net is where you take a listing for, let's say, 120,000, example of a net, and you agree, and the seller agrees with you, that whatever extra amount that you sell this house for is going to be the commission. That is illegal under the Real Estate Act. Okay, so let's say you sell the house for 135 and you list it for 120, and now you're saying, yes, my commission is $15,000. That method of writing the commission is illegal. Are you allowed to charge $15,000 on a deal? Yes, you are. You can say, I want $15,000, but you cannot say, I want the extra amount from the sale of 120. Anything over 120,000 is going to be my commission, is illegal. Any percentage is allowed, any amount is allowed, but net is not allowed. Okay, let's take a look at here. Let's say the brokerage loses their license. Okay, then a managing broker, his license is still good, but the people, the associate brokers and the reps, they will not be able to sell houses because the brokerage has lost their license. The managing broker has not lost his license, but he's inoperative because the brokerage is at a standstill. Okay, if the managing broker loses his license, then all 3 of the other organizations will be inoperative. They cannot do any work. If the associate broker loses his license, all 3 other organizations are still able to perform their duties, perform the work. Okay. If the rep loses his license, all other 3 are still allowed to do their work. Okay, some of the sales procedures. when you start working, your managing broker and your brokerage will teach you all the steps of sales. But for your examination, quickly, we're just going to go through a few topics in when you get a listing. First thing you must do is disclose your representation to your client. Then you get the listing contract. Then you start advertising. Then you start dealing with parties and bringing in buyers and sellers. Then maybe you write up a contract of purchase and sale because maybe one of the parties wants to buy your listing, or then maybe the offer gets accepted, and then you pick up the deposit from the buyer. And then the last step is, once everybody's happy, the deposit is given by the buyer, then you have to fill out a sheet called a transaction or trade record sheet. In that sheet, you provide all the information to your brokerage regarding the deal that you finished up, and then completion will happen through the notaries and lawyers. Okay, for your examination, very important, if you get an accepted offer, or if the offer gets accepted, both the buyer and the seller has signed the contract of purchase, okay, and the agreement is the price has been agreed, everybody's signed, the buyer's signed, seller's signed. Now, a copy of this must immediately go to all the buyers, go to all the sellers. If there's more than one buyer and more than one seller, a separate copy must be provided to them, and both the brokerages, separate copies. Okay, let's take a look at what happens when you get a sale happening and subjects are removed and you get a deposit from your buyer. You as a realtor, if it's your listing and someone else is representing the buyer, that realtor will bring the commission check, sorry, not commission, deposit check to his own brokerage. They will not bring it to your brokerage. If you are representing the buyer, then you will take from the buyer a deposit and take it to your brokerage. And your brokerage will put that money immediately into the trust account. Okay, the trust money, the definition of trust money is a money that's deposited or on behalf of a client for the benefit of another person. Okay, you don't need to know the definition. What you do need to know is that every brokerage must have at least one trust account per service, not one trust account per client or one trust account per file. It's one trust account per service. Remember, there are three types of services that can be offered by a brokerage. One is trading, that means selling houses, buying houses and stuff. And the other two are management of strata and management of rental. If a brokerage does all three, then they need minimum 3 trust accounts. If they only do 2 services, then they need 2 trust accounts. And most brokerages only do 1 service, which is trading services. They hire realtors to sell and buy, so then they would only need 1 trust account. Okay, money received by brokerage must be deposited as soon as possible, as quickly as possible, into the trust account. A trust account is not required for each client, and this money cannot be used for company expenses. Okay, there are reasons that money can be taken out of that trust account. If money's been deposited for a client in that trust account, then money can be taken out to pay the person whose this credit money was deposited for. Okay, it can be taken out for commission of the realtor that had this deal. It can be taken out for expenses of the client, but also it can be taken out if there was a mistake made in depositing money into the trust account. A brokerage cannot take money out to cover any of the brokerage expenses from the trust account. Okay, when you become a realtor, you have to be very, very careful, and you have to do deals, you have to do them legally and ethically. You can be disciplined, and for any items that you do not follow the legalities. Okay, both the managing broker and the licensee and you can be disciplined for the same activity, because the managing broker is a supervisor, and if he doesn't, remember we said vicariously liable, he is responsible for supervising all his reps, so he is also going to be possibly disciplined if there's a mistake or a screw up made by a realtor. Okay, both licensees may be reprimanded or fined. Any appeals, okay, all appeals go to what's called the Financial Services Tribunal. Make sure you know that for your exam. All appeals go to the Financial Services Tribunal. Okay, the last thing that you do is fill out what's called a record sheet of the deal. It's called the trade record sheet or transaction record sheet. In that, you would write the record, sale price, whether it was you were representing the seller or the buyer, or is it a lease. You would write the addresses of all the parties and how much commission you're going to be making and how much commission the other agents are going to be making. What's not required in the trade record sheet for your exam is the date of the MLS listing and any financial institutions that are involved, like where the mortgages are going to come from or where the deposit was deposited. Okay, when you become very busy, you may want to hire an assistant, and you are legally allowed to hire assistants to do some of the jobs. What can they do? Unlicensed assistants may unlock properties for you, do the bookkeeping, they can place signs, they can witness signatures. What are they not allowed to do? They're not allowed to do open houses. They're not allowed to provide advice on real estate to the clients. They're not allowed to get or renew listings. They're not allowed to negotiate or present any offers. And they're not allowed to communicate with consumers about real estate transactions. So they're assistants. They're allowed to do these activities, but they're not allowed to do these activities. Teams. When you become very busy, you may want to form a team. And in the team, there must be at least 2 people. How can you have a team if it's just by yourself? Maximum number allowed by the council? No maximum. You can have as many as you want. But you can only be part of one team. You cannot be part of more than one team. Okay? All team members must be licensed with the same brokerage. The entire team is the agent. Very important. The entire team is the agent for the client. What that means is if there's 3 of you in the team and you get a listing, or one of you gets a listing, that listing belongs to all 3, and your liabilities and responsibilities, all 3 are responsible and liable to that client. And one of you cannot bring in an offer because it is really the listing of all 3 of you. Okay. In terms of team names and team members, must be registered with the council in writing. Okay. If you're going to add people to your team or take out people from the team, must be informed in writing to the council. Okay. Your name for the team must be approved by the council, and if it looks like a similar name to another team, council will not approve it. Very important. If you are doing any advertising and you have your unlicensed assistants or any other person that does not have a license, trading services license, that person must be identified that this person does not have a license. Okay, so the next topic we want to talk about is the 2 acts created by the provincial government, by the real estate. One is called the Real Estate Servicing Act. This is all you as realtors. You have to obey everything this act says. This is for developers. You have to the developers have to do everything this act says. Okay, so the objective of the Real Estate Services Act is to protect the public regarding public properties or property dealings. Okay, there's 5 organizations. Okay, the Real Estate Services Act establishes a requirement of the sales procedure. First step, disclosure of agency, and the last step, doing what's called filling out what's called a trade record sheet. And they decide how documents must be given, if there's an accepted offer, and so on. Okay, this act imposes that everybody who's going to be selling or doing trading must have a license. Okay, they are the ones who, this act decides what is the requirement of the education and how competent a realtor must be. 5 organizations created by this act. Very important, the Real Estate Council and the Superintendent of Real Estate. They're sort of together. Superintendent of Real Estate is what overlooks the council. Okay, so if the council decides to investigate, then usually the superintendent doesn't investigate. But really, superintendent is overlooking what the council does. The other 3, Real Estate Foundation, is more responsible for education and knowledge for realtors and the public. The 4th one, Real Estate Errors and Omissions Insurance. This is a insurance for the realtors if they do any negligent or if they make a mistake in writing contracts. And the 5th one is a real estate compensation fund. It's to do with if any money gets missing or lost from the trust funds. So 5 organizations created from the Real Estate Services Act. First 2, more to do with rules and requirements of the 3 services. Number 3, foundation, more to do with education. Number 4, real estate errors and omissions. It's a insurance company set up so that if there's any problem or realtors have a error or omission that they missed out something on their contracts, then they will be covered. Okay, and the 4th one is to do with trust account. Okay, let's take a look at what the council does. Real Estate Council, that's number 1 right here. So we've got 2 types of acts, what's called RESA, Real Estate Services Act, and the Development Marketing Act. Under the RESA, there's 5 organizations that are created by this act. So the council is one of the organization. It administers the act. It's responsible for the rules, regulations, and the bylaws. It's the one that gives out all the licenses. It renews licenses. And then if it does that, then it has authority to suspend and cancel licenses. And they also have authority to ask for re-education if there's a problem in one of the topics or one of the areas that realtor did make a mistake. Okay, they can be reprimanded. For your exam, you need to know that there are 16 members in the council, and where is the money for the council? Where is the money for the council coming from? It's from the reps licensing fees. Every time when we renew our license or get a license, we have to pay fees, and that fee is covering the expenses of the council. In terms of the 16 members, I wouldn't start memorizing what the 16 total add up to, but I have seen once or twice this exam question, how many reps or any, but really the memorization is 16 members. Okay, more information about the council. They can investigate licensees, meaning reps and managing brokers and brokerages, anytime of all complaints except any complaints to do with realtors commission. Okay, so for your exam, remember they can investigate anytime before, after, or during getting licensed, not during, before or after. Okay, they can impose education, they can cancel licenses, they can reprimand. Okay, they don't need any court approvals to come in and check any documents. So what type of complaints? Anything deceptive, breach of any act, any incompetency. The only thing you got to remember is for your exam, nothing about your commission is an investigation that they will do. Okay, real estate counsel, they can make bylaws in regard to your license application system, the fees, okay, any decisions of the council or the superintendent. Remember, we have the superintendent which oversees the council. So any decisions of these two organizations can be appealed. And for your exam, you need to remember that the appeals are sent to the Financial Services Tribunal. The appeals don't go to any courts. Okay, the Financial Services Tribunal is set up, it's an independent judgment in the financial and customer services sectors. So they can hear your appeals if you feel that there is some council or the superintendent have made an incorrect judgment. So remember, it's the council or the superintendent that can do all the investigations, and they do not need any court approval, and they can investigate anytime before or after getting licenses. Okay, for your exam, you need to know that the council and the superintendent do not do what's called law reform. Law reform is where they change laws. They do have jurisdiction to make bylaws regarding fees and applications. Okay, they cannot do law reform, and they do not enforce code of ethics. Ethics are enforced by boards. Okay, we'll go into board. There's about 10 or 11 boards. They are the ones who are enforcing ethics. The council enforces laws that are made by the Real Estate Services Act. They enforce the laws on the realtors, not ethics. Okay, the membership, when you have a license, the license is given by the council. They have the authority to cancel your license. A membership is given to you by your board, and the board has authority to cancel memberships. So very important for your exam. Licenses can be canceled by council. Memberships can only be canceled by boards, because boards give out memberships. Okay, so the superintendent, right here, second one, oversees and supervises the council. So they're looking to make sure that the council is doing the job correctly. Okay, key power, they make rules regarding licensing, not law reform, not changing laws. Okay, only regarding licensing, not laws for anything else. Okay, again, they can investigate, they can discipline, just same as council. But usually, if council does any investigation, they don't need to repeat this same investigation. Okay, so now we're at real estate foundation. The real estate foundation is more to do with helping the public in education. Okay, again, doesn't do law reform, does not do real estate research. Okay, does real estate law reform and does real estate research. The funding for this is when the money is deposited into the trust accounts for the clients, for the deals that you're going to do for your sellers and buyers. All the money that goes into the trust account, the deposits, the interest from that money is used to run the foundation, the BC Real Estate Foundation. And again, you have to memorize there are 5 members. Okay, number 4, Real Estate Errors and Omissions Corporation. This is a insurance plan for the realtors, not for the public. This is for the realtors. Okay, basically protects the real estate agents against negligence or any duty that they were supposed to perform or they didn't perform. Okay, this errors and omissions does not cover fraud by the realtors. That is going to be something that realtors will have to deal with by themselves. It's $1 million limit per licensee, okay? And every time a claim is paid, $2,000 is deductible that the realtor must pay. Okay, so in this errors and omissions, there's no protection for the realtors if it's the realtor's personal listing. If he's selling his own house, then if there's a mistake made by the realtor, he will not be covered. Okay, if he does anything dishonest or fraud, he will not be covered. It doesn't cover anything to do with commission. Anything to do with discrimination or any sickness, injury, doesn't cover it. Where is the money coming? It's realtors pay $250 per year per realtor, and there are 7 members in this corporation. And the last one, the real estate compensation fund. It's basically any money that goes missing or in the trust account, and this fund will cover that. Okay, very important, the voluntary organizations. Again, they're not really voluntary in terms of they're really required. Okay? They are voluntary, but they're a big part of your becoming a realtor. After you become a realtor, many realtors join the real estate board. Okay, usually they will join the board that the brokerage is connected with. And real estate association, they will also, the real estate association provides ongoing education to the realtors to advance their education. Okay, this is after you get your license done for more knowledge. The real estate board, very important for your exam, they enforce code of ethics. Okay, code of ethics. They provide also the multiple listing service. That's where you research properties for your buyers and sellers. Okay, there's total 11 boards in all of BC. They cancel board membership. Yes, if they feel you're not an honest person and you're not following their code of ethics, they can cancel your membership. They cannot cancel your license. Only the council can cancel your license. Okay. Let's take a look at what are code of ethics. What's ethics? Well, ethics is voluntary. It's integrity, moral integrity. Okay, it's the minimum standard adopted and enforced by the real estate boards. So boards are the ones that enforce it. Boards have adopted these ethics from national ethics of realtors. Okay, it's a higher standard. Laws have already been made, so ethics are higher standards than laws. Okay, ethics are not enforced by courts. Courts enforce laws, but ethics are usually higher than laws. Ethics are not rules. Okay. Sorry, ethics are rules, they're not laws. Okay. When code of ethics conflicts with law, then the law will take precedence, even though the standard of ethics is higher. Ethics may be a higher standard than law, but law will prevail. Let's take a look at the service that's provided by the board, okay, which is called Multiple Listing Service, MLS. Okay, it provides a database for you to list your properties on so that other realtors can view it and call you and put in offers for your listings. Maximum exposure through MLS. Okay, displays property pictures and descriptions. For your examination, the accuracy of, let's say the home that you're listing is 5 bedrooms, but you put in 4 bedrooms, or you put in 6 bedrooms. That's inaccurate information, and that information is yours as a realtor to provide to the board, and the board will put it up on the computer. So the accuracy is the responsibility of the realtor. Any misleading information, you're not allowed to put any misleading information into the MLS. Okay, when you have the types of acts, remember we have RESA and the other one is REDMA, which is for the developers. Okay, we're going to start talking about REDMA now. Okay, in terms of REDMA, we have what's called developers. Okay, well, what are developments? Okay, there are things called strata condo development. That's where a developer is wanting to take the land and build a building like this, and each unit is a separate PID number and separate strata. Here you have townhouses. Again, very similar. A developer will buy some land and make townhouses. Or another developer will take some land, okay, and cut them into smaller portions, which are called lots. Okay, why are 4 here with an X? That means anything more than 4 is required by REDMA to be disclosed. Okay, we're going to get into this in a second. Okay, so now we're going to talk about the second one. Second type is called the Real Estate Development Marketing Act. Okay, and a disclosure statement, usually about 25-30 pages. Okay, I know the word statement means one sentence, but it's not a one sentence. It's a document. I would call it disclosure document instead of disclosure statement. It's a multi-page document, 40, 25, 30 pages, that contain all the information about the development. Okay, this disclosure document must be prepared by the developer, must be filed with the superintendent of real estate, must be in the forms required by the superintendent of real estate. So really memorize this. Okay, this is not important to memorize. Okay, so what is this act? Real Estate Development Marketing Act, this one. We talked a lot about this one. This one, very little on your exam, maybe one question on it. Okay, basically it's imposing or regulating disclosure requirements by developers. Developers are people or companies that take land, and on this land, either they're going to put a high-rise or a low-rise apartment unit strata, or they're putting up townhouses, or they're just taking land and cutting them into smaller portions called lots. Okay, anything to do with industrial or commercial is not under Real Estate Development Marketing Act. This is residential only, people using these properties for living purposes. Okay, so it's protecting purchasers from developers, because sometimes misinformation can be heard, but whatever is written must be disclosed. Okay, to ensure developers have city approvals. Okay, so very important that if you're a purchaser and you're buying something from a developer, you want to know that they already have city approvals. If they're not allowed to sell material that does not have city approvals, and also they want to make sure that the developer will be able to give you ownership, a clean ownership without complications. So those are the two things that the purchasers or the buyers of properties from developers want to be protected. Okay, so a disclosure from the developer is needed if the developer is developing 5 lots or more in that subdivision. if he takes a piece of land and he only gets 4 smaller lots out of that, he can sell 4 of those lots without any disclosure statements. Okay, and 5 or more stratified, meaning townhouses or apartments. Okay, so if he decides to sell all 4, let's say there are more than 4 or more than 5 or more. Okay, if he decides to sell all 5 to one purchaser, then it's probably thought of that that purchaser is also some sort of a developer or a entrepreneur. Then he does not require, the developer is not required to give a disclosure statement. Okay, it's only if he's going to sell one at a time. If he's got 5 to sell, if he bought land and now he's going to have 5 lots there, or he's going to have 5 townhouses on that land, or he's going to make a building with 5 units or more, and he sells one at a time, then he has to disclose. If he sells all to one person or one company, he does not have to disclose. Okay, a new disclosure, this is new. Okay, let's say he's already disclosed, but a new disclosure statement will be required if the developer changes. Let's say someone else buys that property. Now that new developer is taking this property. Now a new disclosure statement will have to be provided by that developer. Okay, or if there's any issues with court or court order or court takes over this ownership, then a new disclosure will be required. Or if the superintendent of real estate is requiring a new disclosure, then a new disclosure will be required. Okay, no disclosure needed. When is a developer not required to give disclosure? Remember those 5 or more? Anything less than 5, he does not require disclosure. If he markets and sells all the lots in one single transaction, no disclosure needed. We already said if it's to do anything with industrial or commercial properties, he can develop as much as he wants. No disclosure statements are required. Only disclosure statements required for residential properties. Okay. If it's going to be anything to do with leasing of 3 years or less, no disclosure is needed. Any subdivision within municipalities, no disclosure is needed. Okay, the purchaser, when he buys something from a developer, has 7 days to rescind. Rescind means to back out of the offer. Okay, purchaser is given opportunity to read the disclosure statement. So after he's read the disclosure statements, he's allowed to rescind. Agents, your job as reps is to make sure your clients have had enough time to read the disclosure. Agents should also read the statements themselves, because if there's something in there that the person misses, you could be sued for that afterwards. Agent can be sued that they didn't. Agents must read the disclosure statements also. Okay, here's a simple way of looking at it. It's a 7 days. 7 days are given to the purchaser to back out after. If there's no disclosure statement provided, and there was supposed to be one provided by the developer, well, the purchaser can get out of that contract before or even after purchasing the property. If he purchases, completes on the property, buys it, and there was no disclosure given by the developer, and if the purchaser is not happy, he can get out. He can rescind. If disclosure was provided, the purchaser has 7 days to rescind after the date of the agreement, purchase agreement. If there is an amended disclosure provided, then it's 7 days after the amended. If there's any changes to the developer, to the development. If the sizes of the units have changed, the townhouses, the amount of townhouses in the development has changed, any changes that have happened, then the purchaser has 7 days after the disclosure of changes has been given to him. Okay, so we're finished with Chapter 2 seminar. Make sure you go to the examination study guide and do all the questions for Chapter 2. And the questions start from question 3 and they end at question 986. You can look at the chart. Okay, now you can also do the assignment number 1 from your licensing course book. We're going to do about 12 more questions before we finish up. Let's do a question. What are the 3 real estate services within the Real Estate Services Act? Okay, here's your choices. Constructing a mall, trading services, home construction. We already said that anything to do with construction is not a service within the Real Estate Services Act. Okay, so this one's gone, this one's gone. Okay, trading, strata property management, I believe this is the answer. Okay, selling, buying, and trading, this is one of the services, but the other 2 are management of strata and the management of rental. So number 3 is the correct answer. Okay, to receive a license, a managing broker must be of good reputation with 2 years of experience anywhere in Canada, Yukon, and he must also, he must also submit his own personal financials required by the council. Read all the disclosure information. Well, this has nothing to do with license. This is disclosure, probably more to do with development or any other disclosure. Nothing to do with his license. He doesn't have to read any material disclosure information to get his license. He submit financial statements of all his licensees they will hire. No, there's no requirement of submitting financial statements. A licensee does not even need to submit any financial statements to get his license. File and prepare the disclosure statements of the developer with superintendent. This is the Real Estate Development Marketing Act. This is not for the managing broker to get a license. So I would say the answer to this is number 1. Submit his own personal financials required. Whatever is required by the council, the managing broker must provide that to the council to get his license. Okay, what categories are exempted from the licensing requirements? What's exempted? What's not required? Okay, who doesn't need a license to sell real estate? Mrs. Jones selling her neighbor's home for $1,000. Well, Mrs. Jones does need a license if she's going to charge $1,000. If she does it for free, then this would be an answer. A would be an answer. She would not be required to have a license. Property inspectors do not need license. Strata managers do not. Employees of a developer selling developer units. So employees of a developer selling developer units are exempted. So this answer is incorrect. The answer to this question is B, C, and D. All of these do not require licenses. The answer should be B, C, and D. Real Estate Council is not responsible for law reform or enforcing the Code of Ethics. Real Estate Council may investigate a licensee of misconduct without a court's permission only before becoming a licensee, only after becoming a licensee, anytime after 2 years. Well, anytime. During, before, or after. Anytime is the correct answer. A developer who is not exempted from the disclosure requirement under REDMA, he or she must provide a disclosure statement to who before writing the purchase agreement, and then the person has 7 days. Well, who does the developer provide the disclosure statement to? To the purchaser. Who does he file the disclosure statement with? The superintendent of real estate. Okay, so who does he disclose to? The purchaser, not to the superintendent. To the superintendent of real estate, he files the disclosure statement with them. Okay, and who has 7 days to rescind? It's the purchaser. So I would say number 2 is the correct answer. A brokerage license may be issued to a corporation if the managing broker hired is licensed in all 3 types of services. The managing broker needs to be only licensed in one service, not all 3. The brokerage's statements are filed with the errors and omissions. The brokerage's statements are filed with the superintendent of real estate, not with errors and omissions. The managing broker has been providing real estate services in Canada, Yukon for 2 years within the last 10 years. No, it's within the last 5 years. None of the above. The answer is none of the above. Which statement is true? A brokerage is a physical location that must be a partnership or a corporation. That is true. Brokerages must have a licensed managing broker and with or without an associate broker. They can have an associate broker if they want. They don't have to. But they must have a licensed managing broker. A licensee cannot work independently and for more than one brokerage. Well, this is true. All 3 are true, all of the above. So right here is we're putting the slides where this information is really from. So it's a good idea for you to go through the slides when you're answering the questions. Question 8. What are the powers and the duties of the real estate council? Hold disciplinary hearings. Yes, they do that. They levy fees on licensees for council expenses. That's how council expenses are covered. Fees of the realtors. Collect fees from licensees for the errors and omissions. Yes, they collect the fees for that. I would say all of the above is the answer to this question. Under which circumstances does the Real Estate Services Act permit the brokerage to withdraw money from the trust account? Well, let's see. Instructions of the owner to whom the money was, yes, they're allowed to take money for the client that was deposited money for. Money for commission of the broker, yes, they're allowed to take money out. Money deposited by mistake, yes, they're allowed to. Money required for expenses of the brokerage, this is a no-no. D is the only one that's not the correct answer. Okay, so A, B, and C is the correct answer. Question number 10. Which of the following statements regarding commission are true? Be careful in some questions. If it says which of the statements are true, then you're just looking for true statements. But now you're looking for true statements regarding commission. Okay, so there may be some true statements here that are not regarding commission. Those are not the answers. Okay, now we only want to know about commission. A licensee must disclose to his or her brokerage the full amount of commission received. Yes, this is true. Full amount of commission must be disclosed. Commission may not be based on the difference between the list and the, yes, this is true. The net commission, we're not allowed to charge net commission. Real estate trading services must be provided to the seller according to a written service agreement. This is a true statement. C is true, but it's got nothing to do with commission. So that is a wrong answer. This is not a true. This is a true statement, but it's not a true statement regarding commission. The Real Estate Services Act restricts a licensee from charging commission lower or higher than. No, they do not restrict. Real Estate Act allows you to charge as much as or little as possible. So I would say the answer is A and B. Okay, so number 11. Which of the following will not qualify as a real estate service? Real estate service. Okay, remember there are 3 real estate services: trading service, managing brokerage, managing strata, and managing rental property. So selling a house, that means trading service. In Kelowna, for your sister living in Toronto. They could be living anywhere as long as the selling or the buying is happening in British Columbia. Kelowna is in British Columbia. If it was the other way around, then it would be an incorrect statement. As a realtor, your license is given to you by the Provincial Real Estate Services Act, the Council of British Columbia. Your license is only good for the province of British Columbia. In order to sell in Toronto, you would have to get a license from Ontario. So if this is changed around, selling a warehouse in Toronto for your sister living in Kelowna would be an incorrect answer, incorrect statement, because your license is only for selling, buying, trading, leasing properties, residential and commercial and industrial in British Columbia. It doesn't matter where that person's living. Collecting deposits for the use of real estate tenants. If you had a license of managing rental properties, then number 2 you're allowed to do, if you had a license. And it says which ones do not qualify. Well, it will qualify if you have a rental management license. Collecting strata fees. If you have a license to manage strata, then this is allowed. But if you only had a license to do trading, then number 3 would not be allowed. But we're just saying which ones do not qualify as a service. This is one of the services that could be constructing. You always look for the word constructing. Constructing a home for the managing broker for a small fee is not a real estate service. So the answer is number 4. Okay, practice question 12. Which of the following guidelines of the Real Estate Council with respect to the teams must be followed? Okay, guidelines set by the council regarding teams. Be careful again. Sometimes the statements are true, but nothing to do with the teams. Licensed team members must be licensed by the same brokerage. That is a true statement. Licensed team members must inform the council if any member leaves or joins. That is a true statement regarding teams. A managing broker must have 2 years of experience within BC, Yukon. This is a true statement, C, but nothing to do with teams. D, a listing must identify all unlicensed persons in an advertising of the listing. That's a true statement also, but nothing to do with teams. So the answer is A plus B. If the question had said, which of the following guidelines are true in terms of Real Estate Council, I would say all 4. All of the above, but if it's only to do with teams, it's A and B. Okay, we are finished with the chapter 2. I hope you enjoy, and please give me a call at 604-808-5400 to discuss anything further.